A vital question that is put to us relates to the relationship between the direct selling network marketing MLM industry and the FTC. And it has been a bumpy road. I can say that today it's a cooperative road. But early on, in the aftermath of the Dare to Be Great pyramid schemes in the 1960s and 1975, the FTC challenged Amway as being an illegal pyramid scheme. After 4 years of litigation in 1979, an administrative law judge of the FTC ruled that Amway was a legitimate business opportunity, which has now paved the way for every other company that has ever come along. The ruling was based on the fact that Amway promoted retail sales, had a buyback policy for people who had inventory and wanted to leave the business, adopted a 70% rule, encouraging people and telling them that please don't buy more product unless you have either used or sold the product that you have previously purchased. These came to be known as the Amway safeguards, and they're cited in every case ever since. And that was the last that the industry heard from the FTC for the most part, other than various product-related issues, until the mid-1990s, when the FTC started to revisit the question of personal use by distributors. And some of the consent decrees that with companies that were really egregious violators, not adjudicated rulings, but consent decrees, the FTC's position was that at least 50% of product needs to be sold outside of the distributor network for a company to be legitimate. This put a lot of tension on a lot of companies, particularly health products companies that have a lot of personal use. There's been a lot of debate back and forth. There have been a number of states at the request of the industry that have changed their pyramid statutes to recognize personal use as a legitimate destination, and an ongoing dialogue occurs with the FTC. Today at conferences, the industry conferences, the FTC is a participant, and it always tends to assure the industry that it recognizes the legitimacy of the industry. As a matter of fact, just a couple of years ago, the FTC sought to modify its business opportunity rule and considered some options that would have made it much more restrictive to recruit for MLM companies. After an onslaught of letters and comments to the FTC modified its position on the business opportunity rule and basically came into agreement for the most part with the industry on how things should go. There will always be tension between the FTC and the industry on the issue of personal use, but overall there seems to be a consensus, and it is the observation in the industry that the FTC chases after egregious companies and does not chase after what we would normally consider to be legitimate companies.